channel afterwards. So there's sessions for members of all 3 of the networks. Do send us suggestions and questions on the chat throughout. What we're going to do is I'm going to turn over to Matthew Smith and Debra Gers from Blake Morgan LLP in just a second. Matthew's a partner with the firm and Debra's senior practice support lawyer there. We'll have around 2 or 3 opportunities for Q&A, probably about 20 minutes in and around 45 minutes, something like that. So if you put questions on chat, I'll kind of manage all those, and also there'll be those slots if you want to save them for there, whatever you prefer. We're going to have a hard finish at 3 p.m. But for now, I'm going to turn right over to Debra and to Matthew. Thank you both for doing this, and the floor is yours.
Right, well, thank you very much, Richard, and thanks for the invitation. So I've set up the slide there, and you can see what we're going to be looking at today. And this was agreed with Richard in advance. We thought we'd focus on the hot topics and the looking ahead, and the case law developments would be at the very end, just a handful of cases, literally, from last year, because we thought most benefit would come from looking at the key issues that you're probably dealing with, including the coronavirus retention scheme, remote working, and returning to work. So Matthew and I will do the session between us, and I'm going to start off with a very quick update of the furlough scheme. So I can't imagine that anyone thought when this was set up in March and we all got very excited about the scheme, a temporary scheme that was supposed to last for 3 months, and here we are. It's been extended yet again, and the current date that it's working to is the 30th of April. So that was the date that was extended to back in December. The government didn't carry out the review in January about looking for employers' contributions, so they're still paying the 80%. And obviously employers need to pay NIC and pension. So what's new under the scheme? A couple of things which are worth pointing out. So we've got some new guidance, and this just confirms and reiterates that those with caring responsibilities can be furloughed. So that was the position anyway, but with the new national lockdown announced at the beginning of January, this guidance, which was published immediately afterwards, now confirms that if you have caring responsibilities, so caring for children who are at home or caring for a vulnerable individual, then you can be furloughed. So that's something I'm sure we'll be coming back to later on. What's really new? This is an interesting development, and this is all about how to tackle furlough fraud and to increase transparency. So you may have read about this, that employers claim information, furlough claim information, where they are made after the 1st of December, is going to be made public on a government website. And that's going to be in 2 phases. So from the 26th of January, employers' names were published. And then from February, we don't have the date yet, there's going to be more information which include the value of the claim. So we just stop there for a moment. It's hard to imagine, but some sort of furlough fraud has been along the lines where individuals don't even know that they've been furloughed. So the employer has been claiming for them, and the individuals are just working as normal. So the employer is obviously defrauding the scheme. So this scheme now with the transparency is designed to make it much more public. So you can actually go on and check if your employer is making a claim under the scheme. And from February, you'll be able to see what's the broad amount of the claim. So this scheme started on the 26th of January, so literally 2 days ago. It is working. The first batch of names have been publicised, and there's already criticism about the lack of transparency, because those employers that are listed at the moment, about 750,000 of them, don't include anyone that made claims before December. They don't include employers who've already paid back the grants, and they don't include employers who have asked for their information not to be made public. So we'll have a look at what that is next. So if you think that you're going to be at serious risk of violence or intimidation, you can ask HMRC not to publish the information about you, your name, your company number, and how much you're claiming. And the current numbers, the ones published just 2 days ago, don't include those employers who have an application pending or where the application has been dealt with, i.e. HMRC have agreed they won't publish the information. So if you don't want your information to be published, the guidance that came out on the 13th of January tells you how you can do that. If so, for whatever reason, you don't want to have your information published, this is what you need to do. So use your government gateway user ID, AY reference number, and so on. But you'll see from the very last point there, you'll need to provide evidence in support of your application, not for the information to be published. And this is what you'll need to provide. So why you think you might be at risk of violence or intimidation. So if you already have, it could be a police number, an incident number, any documentary evidence, have you had threatening emails and so on, and evidence of possible disruption or targeting. So the guidance of the 13th of January, you'll be able to get more information there. And what's interesting, as I say, 2 days ago, the first group of names were published. The first group of names, as in all those are going to be published so far. And what people are saying is there's a lack of transparency because HMRC are not giving any information, even about the numbers of employers who've actually asked for the information not to be published. You can quite understand they're not going to give you the details, but we don't even have any idea how many employers may be asking for the information not to be made available. So that could be quite disadvantageous if they're trying to increase transparency, because we'll have no idea at all. Again, to increase transparency, HMRC are actually going to make more information available to furloughed employees. So you'll actually see from your own personal tax account where claims have been made for you. And again, that's obviously because in the past, some employees didn't even know that they were being claimed for. And it's all to do with the possibility and the risk of furlough fraud. So we've got some statistics here. This is HMRC's own account back in September, that up to £3.5 billion may have been claimed fraudulently. They've had almost 2,000 reports to its fraud hotline. And a lot of money has already been returned voluntarily. So that's very good PR if you're able to say, we're returning all our money, or we don't intend to claim any more because our trading is improved. So any other changes to keep an eye out? Well, definitely the budget. The Chancellor's already said that if there's going to be any additional support for businesses and workers or any extension to the furlough scheme, it will be announced in the budget on the 3rd of March. But there's a good chance, I think, that there'll be an announcement before then, because the criticism at the last extension was it was so late in the day that some employers had already made decisions to let go of staff or to make people redundant. And then the criticism was if they'd made the decision to extend a few weeks earlier, they wouldn't have been put in that position. You'll see that the CIPD and CBI both want the furlough scheme to be extended at least until the end of June, and the TUC have called for an extension to the end of the year. The job support scheme, which was that very complicated replacement for the furlough scheme, where employees had to work a minimum of 20% of hours, and there's no idea if that's going to take the place of the furlough scheme as and when it eventually ends, or will there be a similar type of furlough scheme but much more targeted to specific sectors. And again, we don't know if the job retention scheme bonus will ever be revived this year. So that's the update for the scheme. Keep an eye out for the published information. And as I say, there is a process to go through if you don't want that information to be published at all. So the next thing that we're going to look at, and after this section, managing remote work, and we'll have a break for questions, but Matthew and I will do this one between us. And I think we'll probably spend more time on this, and you may have lots of questions on this section as well. So obviously we're in another lockdown now, another national lockdown, and it is very hard work, I think. I think this one, people who were joining the call in the beginning were talking about, difficulties of managing work, childcare and so on. I think in the first lockdown in March, it was spring, it was new, we didn't think it was ever going to last for so long, and here we are 10 months later. So one of the very first things I want to mention about remote working, I think it should be a priority, is mental health. Because we all know, whatever statistics you read, whatever surveys are published, mental health and concerns about poor mental health have increased across the board for all ages. So there are reports from Office for National Statistics, from Mind, Prince's Trust, and that's got information about young people's mental health. So 1 in 4 young people say their mental health has worsened. according to the ONS, 20% of people who never had poor mental health before are now experiencing concerns with their mental health. And if you think about what the health and safety executive identify as workplace stressors, the management standards, so that's things like control of your work, workload, support, relationships. You can see why working from home for many, many months, which increases social isolation, can obviously have an impact on your workloads and how you feel. And I think that the difficulty is the social isolation combined with all the other factors people may have, looking after children, homeschooling children, maybe caring for somebody who's ill, maybe having suffered a bereavement, their partner's on furlough, the partner's lost their job. So all of those things combined is very, very, very stressful. And I think if you combine that with the social isolation, it's very hard to say that, and the inability to disconnect work from home. So people can always access their emails, they can always go and work on a document if they need to. And then look at things like physical workspace. Do you have a spare room? If you do, you're very lucky. You might live in a bedsit, or you might be sharing a flat with other young people. You may not have enough space. You may not have the broadband. So all of that is going to make it very, very stressful to combine working from home with all the other elements of your day-to-day life. Cyberbullying and harassment, it's really sad to say, but that's actually increased. The reports are that that's increased. So sexual harassment in particular, a report was published just a couple of months ago, and of 42% of people who were complaining of sexual harassment said that the harassment was online. And there are serious concerns that where there's the increase in the use of technology, video conferencing and so on, then your privacy is actually being eroded horribly if that you're then being subject to cyberbullying and harassment online. So what can you do to support staff well-being? I think the key message is be proactive. So from the employer's perspective, be proactive. Generally, first of all, so what resources do you have? What support do you have available? What can you offer your employees? So do you have mental health champions, mental health first aiders? Do you have online resources? We have a winter wellbeing campaign at Blake Morgan at the moment. And so every other day, more information is published, how to control anxiety, how to get more exercise, things like that. But you also need to think about specific individuals. So if you are a manager of a team or a particular department, you know enough about the individual members of staff, hopefully, to know if they've got children of school age, in which case they'll be homeschooling as well as trying to work. Or you'll know if they've got caring responsibilities, or you should know if they've had a bereavement. So in those specific circumstances, you can think then what additional support does that individual need? And what can you offer? Maybe more time off, or the option of furlough if you discuss, is that something that would help them for the moment? Or even flexible furlough, some time off and some time at work. And of course, if you don't do any of those things, there's a chance that the people will become more stressed. They may be taking leave for sickness reasons. If you look at the case of bullying and harassment, they may put in a grievance. They may even resign. So all sorts of reasons why you do need to proactively manage employees' mental well-being, and of course any other aspects of their working life which is causing them concern. Now, the last thing I want to mention about remote working before we get to Matthew is there's been lots of concern about younger workers or junior employees. They don't learn on the job, learning by osmosis, informed learning, informal learning and knowledge sharing. All of those things are more difficult if you're working from home, because so much learning is done just by sitting next to people or listening to them, sharing a cup of coffee. And we have a particular issue because we have trainee solicitors and they join usually every September. So the whole group that joined in September, we've never met them in the office. They're all working from home. So I think the key thing to remember is that you can still do it. It takes a little bit more effort, that's all, if you want to, keep your junior staff on board. And also I think it's worth making the point, probably applies across the board. It's not just junior people, everybody likes to keep on learning. So you need to make more of an effort and spend a little bit more time thinking what you can do. And I think the starting point is give some thought to what somebody might be missing out on by not being in the office with you and sitting next to you or sitting at the same workstation, and what they're missing out on. How can you remedy that? How can you replace that with something? So all sorts of things. We'll have informal buddy schemes, more formal mentoring, more supervision, people joining you at a particular telephone call with a client, for instance, that would help, attending online meetings. So all of those things are feasible. They just need a little bit more effort to organise and to make sure you're not forgetting about your new joiner. Ensure that they still have networking opportunities. So I've found increasingly now that any webinar I attend, an Employment Lawyers Association one, for example, they put half an hour either side for networking. So you have your main webinar and then a networking opportunity either side. And I think the other thing probably a lot of us will need to learn more about is the technology, because there is a lot of IT supports, platform systems that can use to help these junior people have more contact and maintain contact with you, even though they may be working in a completely different place. And in relation to new joiners, I was just thinking, I have a couple of friends who've started new jobs in lockdown, so they've never worked in the office. And I think it's all the above that we've mentioned there, but also give particular care to the induction process. And I know one thing that one of my friends found particularly helpful was a pre-induction sort of meeting where they met other people who were joining the organisation at that time. So they had that informal group contact beforehand. And the other thing is, I would say, top tip, IT support, a specific point of contact in IT, or a particular contact number, or the new joiner's name to be given to IT and cause to be dealt with as a priority. And I'm sure that would help massively if you were a new joiner and not meeting any of your colleagues at all. So one other element we want to look at then for remote working is the thing that Matthew's going to look at next, which is disciplinary grievance and capability matters.
Thanks very much, everybody. I was predicting that disciplinaries and grievances would go down because people would be pleased to be in work and to have a good job. It turns out that that's not the case, or at least not on the basis of our recent experience. And there are still a number of disciplinary issues that crop up, and grievances, and indeed capability issues. And so the guidance really is to say, well, everything's as normal, except where it isn't. So the obligation on an employer is the same as it ever was. You need to deal with these things without undue delay. And of course, the fact that people are working remotely or on a furlough does make things more complicated. The fact that someone's on furlough doesn't prevent you from dealing with a disciplinary or a grievance or capability issue, but it does mean that you need to give careful thought to the practicalities of it. And I think the best guidance in many ways is to say, look, imagine that the tables were turned, and that rather than running the disciplinary or grievance, you were the person who was the subject of the disciplinary or who was bringing the complaints. And if you feel that you'd be being dealt with fairly and that the technology was appropriate and the arrangements were suitable, that's a pretty good indication that you're doing the right thing. You can obviously get reassurance on that front by looking at the specific ACAS guidance in relation to this area. That's available from their website. And then there are some things that are relatively obvious. Is the technology up to it? Is the broadband going to hold out? Have people got the devices that they need to present their grievance or to answer a disciplinary case? Can they see the documents that are relevant? Do you send those by email? Will you need to courier them and allow time for them to be quarantined for a bit? It's all these sort of things you just need to give thought to in advance. And of course, you need to bear in mind the issues of difficulties and distractions with doing things remotely. There's a fantastic thing on the BBC website of all the things that went wrong in Zoom interviews that they were doing. And it's people's interviews being timed out by Zoom or being interrupted. And it's all that you need to bear in mind. Has someone got the chance to be in a room where they can deal with this issue and not be interrupted or distracted? So try and think through it as much as possible. One of the things that we found is the unexpected companion in the Zoom area. So cases where people, we didn't think they had a companion in the meeting, and lo and behold, it turns out that they do. And of course, that person isn't necessarily someone who's got a right to be there. So instead of being the companion or a trade union rep joining on a Zoom call, a colleague or a trade union rep, you end up with someone who really shouldn't be there at all. And some of those interventions have been quite lively and on occasions also actually unpleasant. So it's very important to try and establish that as far as you can. And you will need to bear it in mind when you're making decisions about whether someone's telling the truth or not. You know, have they got someone there who's prompting them? Are they getting assistance that they shouldn't have? And those sorts of things are quite challenging, I think. And there was a story I heard, which I am assured is true, that over the summer when it was very hot, one individual thought it was appropriate to do his redundancy consultation meeting in his pants. So I'm afraid at that point they then had to tell him to turn the camera off so that they weren't disturbed by that. But it gives an illustration of the sort of problems that can crop up. Well, as I say, the general principle is if it needs to be dealt with, you should deal with it promptly and make sure you thought through the practical arrangements. That slide then just confirms there with a link to the specific guidance. And as I say, if you feel like you've been treated fairly, if the tables were turned, that's a pretty good guide as to how to deal with it.
Okay. Right. And before we go on to the next topic, I think we were breaking there for questions, Richard. Is that right?
Perfect. Yes, please do. So any questions for Matthew and Deborah, please feel free to raise your hand. We've got, I think, just over 50 people on the call. So just hit that hand symbol at the top right-hand corner, as I'm sure you know. Matt, thanks. Welcome.
Hi, Richard. Hi, Matthew and Deborah. Just it's just a point of information, really, Matthew, in terms of current employment tribunals and what's the status of the courts at the moment. I mean, touch wood, none of us will need to get involved, but it is just helpful to understand how they're working through caseload.
Sure. Yeah, we're going to cover that a bit later, but I can give you a heads up now, which is to say the system is struggling. There's an enormous number of new cases coming through. Admin is behind, and although the system of remote hearings is working well, the backlog of cases is tricky. And we've had situations where claims are being served on employers a long time after they were delivered to the tribunal. So they're claims that look like they might be out of time, but actually they're not. It's just taken a long time to get through. So I'll come back to that in a bit more detail on a later point. But the answer is there's a lot more claims. The admin side is struggling. The hearing side is okay with the remote video platform, but it's not as smooth as it would normally be.
Thanks, Matt. Appreciate it. And thanks, Matthew. From Lucy here, will there be any customs and practices from this year that will be hard to be challenged when we go back to a different normal? Would it change contracts? That's a good question.
That is a great question. The short answer is possibly. I think it'll be more difficult, I think, to resist requests from staff to work remotely or to have flexible working arrangements because the fact that someone has done their role successfully and productively from home will make it much more difficult to insist that they be present in an office environment. There may also be people who previously had a requirement to do quite a lot of traveling as part of their job, and I think you'll find it'll be harder to insist that someone must do either nationwide or international travel, and we've all managed without that for the last year or so.
Great, thank you. And then just moving to Julia, thanks. Julia Perry.
Right, yes. We're in the fortunate position of not having needed to furlough anyone, but one of our members of staff who's currently on maternity leave has worked out that she will be financially better off if she goes on furlough rather than remaining on maternity leave. Can you give any guidance around that?
I think you need to work backwards. So really, what's the point of the furlough scheme? And the stated published reason for it is to help employers in these unprecedented circumstances where their business has been affected by COVID. So that's obviously designed to, to help people keep their jobs and to avoid redundancies. So you could argue that's possibly an abuse of the scheme, so there's no need for her to be furloughed except for a personal financial reason. So that's really a decision you would need to think about the purpose of the scheme and why would you be making use of it, because that reason for wanting to be furloughed is unconnected to the pandemic, isn't it?
Yeah, absolutely.
I think, Julia, the other way of looking at that is to say, what would be the position if the employee's maternity leave came to an end now? If the answer is we'd be furloughing her, then as long as they've gone through the right procedural steps to end maternity leave before it was originally intended, then that might well be okay. If the answer is in any other circumstances, her maternity leave came to an end, she'd be back at work working from home, then I think it's more difficult to justify using the furlough scheme.
Okay. Thank you.
Thanks, Julia. Thanks, both. One last question just from Kerry, and then we'll move on with another Q&A in about 15 minutes. So Kerry says, we're looking at reverting some staff to home working on a permanent basis. What's the legal view of removing London allowances if we do that on a voluntary basis? We've had that in the WhatsApp chats, actually. That's a good question.
So the answer is, I think that it depends on whether those allowances are part of your contracts of employment. If they are, you would need either the employee's agreement to remove the London allowance, or you'd need to go through a process of dismissal and re-engagement to change the terms and conditions where that change wasn't agreed. And in that situation, of course, there's the possibility that people will refuse to accept the re-engagement on the new contracts, which omit the London allowance. And then you have the possibility, therefore, of unfair dismissal claims from those who've got enough service. I think that the question is, obviously there's different ways of approaching it. You could either completely remove the allowance, or you could look at some tapering over a period to lessen the impact, and that might be more likely to get people's agreement. So you wouldn't need to go down a dismissal and re-engagement route. But I think in most cases, something that goes to someone's remuneration will be part of their terms and conditions of employment, and you will need consent or the dismissal and re-engagement route if that doesn't succeed.
Thank you.
Okay, great. Let's we'll have another Q&A in around 15 minutes. For now, keep them coming on chat, and I'll manage those and save them up, or wait for that 15-minute slot, whatever's best for you. Matthew and Deborah, back to you. Thank you.
Thanks, Richard. So now we're looking at managing the return to work. So obviously there were some organisations that never closed the workplace. So for whatever reason, manufacturing or retail and so on. So their workplaces have never had the problem of closing and then managing the return to work. And others then opened again in the summer, depending which part of the country, what tier you were in. Wales always had the guidance of work from home if you can. So where there is a return to work, or you're thinking about it, or where there will be, then you need to obviously remember that you have a duty of care for staff, customers and visitors, and you need to make the workplaces COVID-19 secure. So I just make a very obvious point, but it's worth mentioning. The guidance is extensive and it's different across the UK. So sometimes that's not really coming across very clearly in news reports or in the media. But a lot of the time when the Prime Minister's making an announcement, that guidance he talks about is referring to England. But the good thing for you is that if you go onto the HSC website, it links to all the guidance relevant to the different nations, and it is different. So you do need to look at that. And what you will find as well then is specific guidance depending on the sector and the type of work. So it could be for offices, for retail, all those different areas and sectors of work will have different guidance. So if you have taken people back to work or you never closed, in both circumstances, you would have carried out, hopefully, a COVID-19 risk assessment. And that is now going to be part of the risk assessment you would have done anyway, because obviously you're under health and safety obligations to carry out such assessments. And the COVID one should take into account the specific risks that particular groups or individuals might face. So we know from public health research that certain groups are at a higher risk. So certain ethnic groups, age has an effect, obesity levels, all of those can impact on someone's susceptibility to catching COVID and developing it. The employers need to develop, cleaning, hand washing facilities, social distancing, ventilation, all those things. As I said, the best place to go for all of that is the Health Safety Executive Government UK website. It has everything you could possibly need on there, and links to all the national guidance as well, and additional links to templates for risk assessments, self-assessments for home working and so on. So a massive amount of guidance that's available. But what are the particular issues for employers? So I've set out some of the key questions you need to think about there, and what the difficulties are. So if you are now asking people back, or you will be shortly when you think the lockdown is going to end, why are you asking some people to return to work now? What's the reason? Is it because lockdown is eased? Well, that's not the case at the moment. Or is there a business reason that you need? The job cannot be done at home because of the need for certain equipment, organisational reasons. So, you know, not on a whim. You need to have a good reason to get people to come back to work, to ask them. And how do you decide who needs to return? Well, if your workplace is never closed, so you're a particular manufacturing business, for instance, you probably haven't had to make that decision at all because you just need everyone. And what you've been doing instead is how do you make that workplace safer by social distancing and so on. But if you do need to make a decision, then clearly you're going to need to think about certain people who ought not to be working. So clearly the vulnerable, clinically vulnerable, maybe pregnant staff. What should you say to them? So obviously, if you've been working from home happily for many months and all of a sudden you're being asked to go back to work, you want to know why. So you're going to need to explain to staff what the reason for the return is, why that's going to be necessary, and importantly, what have you done to make the workplace secure? So that's to reassure them about all the steps that you've taken to be COVID-19 secure and all the steps you've taken to comply with the relevant guidance. And then in case of people who are, now this is a really common problem, you know, lots of people saying they don't want to come back, they're concerned about their own health. And what can you do in those circumstances? If they're really concerned, then the starting point is to reassure them. So it's to find out what their concerns are. Do they have specific concerns, or are they very general? Do they have concerns about their own health, or are they not happy about what you've done in the workplace? So you need to explain what steps you've taken to make the workplace secure. And obviously, this information, the risk assessment, should be published and made available as best practice for all employers, really. If you're a very small employer, you don't need to do that. But I imagine most of you will be publicising the results of your risk assessment and how you've overcome any risks and what steps you've taken. Commuting on public transport, that's an interesting one if you are opening the workplace, because obviously you have responsibilities as an employer whilst people are at work. But that doesn't extend to people travelling to work. If they're working and travelling is part of their role, then clearly you do have responsibilities, but you're not responsible for the commuting. But having said that, there is a pandemic and there are steps you can take to remedy those concerns as well. And in fact, there's government guidance, English government guidance, but there's equivalent guidance as well, specifically about transport, travelling and using public transport. And that's got a whole list of all the sorts of things as an employee you could do. So possibly, you know, you could stagger your start times so people don't all have to travel in the rush hour. You could change shift times. Is it possible that in these current circumstances, with fewer people in the office, you can actually provide more car parking facilities so people don't have to use public transport? You know, all sorts of things that you can think about. And obviously, if you get specific information from individuals about what their concerns are, then you may be better placed to deal with them as well. And then what can you do if an employee refuses to return? And we're going to look at that in more detail when we get to the next slide. But the refusal depends on the reason for refusing. So if it's because you have done nothing about your workplace being made secure, you can't show that you've taken any risk assessment, and you have, then clearly the employee is going to have a better reason for refusing to return. If you have done everything that you were supposed to have done, and the employee, for instance, doesn't have a specific underlying health reason why they shouldn't return, well, then your response to why they don't want to return will differ depending on what you have done as an organisation and what the reason might be for them not wanting to return. So as I said, we're going to look at that in more detail with the next slide, but I just also want to mention where things don't go quite to plan. And obviously the DVLA have been in the news a lot over the past couple of days. It's not the only organisation. Some courts have been criticised as well, but the DVLA in particular, I think they've had over 500 cases of COVID there in the last 3 or 4 months. And the reports from inside, from the staff, that the big problem there is lack of social distancing, so that there isn't the space to be socially distanced. And the other concern is a lot of them could be working from home, but they've been required to go into the DVLA. So that's when it doesn't go well. You're going to get lots of adverse publicity. So what I want to look at now specifically, this is a very busy slide, lots of information on there. So just to break it down. So the Employment Rights Act protects employees from unfair dismissal. And there's a specific section relating to health and safety concerns. So if you're raising a health and safety concern, if you have health and safety responsibilities as a health and safety rep or employer rep, for instance, this provision of the Act, Section 44 and Section 100 are really important in the context of COVID, because this is probably where we're going to see lots of new tribunal claims in the months ahead. So what we have is Section 44 protects an employee from suffering a detriment, where they raise a health and safety concern or they won't go to a premises because they think it's dangerous. And the detriment could be disciplinary action or not being paid. And Section 100 is protection from dismissal in the health and safety context. And if you look specifically at Section 101D, that provides that where an employee reasonably believes that they're in serious and imminent danger, they're protected from dismissal if they leave, propose to leave, or refuse to return to the workplace while the danger persists. And unlike the usual ordinary unfair dismissal, there's no 2-year qualifying period. It's a day one right, and compensation is unlimited. So looking at Section 101D, how will that arise in this current pandemic? Well, the issue is if an employee reasonably believes that their workplace isn't safe and there is serious and imminent danger, and they refuse to return because they believe there is a serious and imminent danger, if you were deciding to dismiss them, that dismissal could potentially be automatically unfair with unlimited compensation. So the issue here is COVID, or the risk of it, likely to be serious and imminent danger? And when this provision was developed, the sort of scenario that this would have applied to is something like a fire. So a fire erupts and clearly you're in serious and imminent danger and you would be able to leave the premises or refuse to go back. And you can see why that would easily apply in that context. But with COVID, is it serious and imminent? Depends on your tier. When we were into tiers, were you in a part of the country where the rates were very, very high, or was it a low rate? Is it going to be imminent? Are you an individual who's perfectly fit and healthy, young, with no underlying health problems? Are you personally going to be in serious and imminent danger? And I think obviously we haven't had any cases on this yet, but we certainly expect them over the months to come. And I think the tribunal will probably give a broad meaning to the word danger. So it could be that COVID will come within that. But the issue then is, does the employee have a reasonable belief that they're in serious and imminent danger? And the reasonable belief may not be a reasonable belief if the employer can show they've actually done everything possible to make the workplace secure. They followed all the government guidance. They can say that this individual isn't at a particular risk. So we don't know yet what approach the tribunals will take, but we can certainly expect Section 44 claims or Section 101 claims in the months ahead. Some have already started, probably. They just haven't made their way through the system yet, and certainly we have no reported cases. But a very, very important area to be aware of, because this is relevant to where the employees are saying they have concerns about coming back or refuse to come back at all. That's the issue that we have in that scenario then. I think Matthew now is going to look at the current issue of vaccinations.
Thanks very much. I'm sorry that we're presenting with really sort of A to Z of minefields for employers. And this is another one because vaccinations are, of course, extremely good news in the general context, but they're not absolutely straightforward if you're an employer. So let's have a quick look at what the issues are and what that translates into practice. Starting point is what Debra's just been talking about. You have an obligation to make sure that your workplace is safe, and you have an obligation to take reasonable steps to remove workplace risks. Now, there's two aspects to this in terms of vaccinations. The first one is that clearly encouraging staff to be vaccinated is part of your management of workplace risk for COVID-19. But also, if you know that staff are refusing or have refused to be vaccinated for whatever reason, you need to factor that into your risk assessment as well. So there's those two aspects to it. What's clear is that there are some limitations to requirements or insisting on vaccination. For a start, being vaccinated isn't mandatory anyway. And secondly, of course, at the moment, the vaccine's not commercially available. So we're seeing across the country the way in which the groups are being prioritised for vaccination. It's simply not possible for everybody to be vaccinated at the same time. And we've seen that depending on occupation or vulnerability, or in particular age groups, which I'll come back to, the vaccination programme is running at different speeds. In terms of the general idea of whether you can require people to be vaccinated, it's very important to look at the particular sectors. Obviously, in some sectors like health and social care, a requirement that staff are vaccinated is much more likely to be acceptable, indeed necessary, because it's part of managing that health and safety risk. And it's in common with the requirement on healthcare staff to be vaccinated for other conditions more generally. If you're not in those sort of sectors, what's the position? Well, I think the answer is that you can't require staff to be vaccinated. There's ACAS guidance on this as well, which is well worth a read, and that essentially says, absolutely, by all means, encourage your staff to be vaccinated, give them the information that they need to make an informed choice as to whether they're vaccinated or not, but that you can't force them to be vaccinated. And it's also very important, of course, to say that you shouldn't regard vaccination as the be-all and end-all. You shouldn't abandon other protective measures that have been put in place for workplaces, not least because the vaccine is not 100% effective, and because it's still not absolutely clear whether it prevents transmission of COVID or whether it simply abates the symptoms for those that have got it but have been vaccinated. So clearly, it's important to bear those things in mind. Let's have a quick look at the legal framework. Is it a reasonable instruction to say to someone, please get vaccinated? For a doctor or other medical staff, I think the answer is yes. For other staff, I think the answer is probably no. In other words, it would be difficult in most circumstances to discipline someone for refusing an instruction to have the vaccine, but it will depend on the circumstances. And for example, it's going to depend on the reason for the refusal. It's going to depend on what other measures you could take that would be effective to try and prevent transmission of COVID. So could you have different arrangement of office space? Are there other ways that you could deal with it, including, of course, home working? Can you have a contractual requirement on people to be vaccinated? Well, you won't have that now. So it's, as we were saying in relation to the London allowance question, a change to terms and conditions of employment. So you would need to make sure that people agreed to it. And if they didn't agree and you were going to insist, you'd have this process again of dismissal and re-engagement. So the question is it really necessary to make it a contractual term? It might be possibly for staff who've got an international travel role where countries they go into require vaccination, but for other staff, I think it's less obvious. So the next bit of the minefield that we need to go through is the question of, does it give rise to claims? And the answer is potentially yes. You need to be very alive to the possibility of discrimination claims. So let me just give you an example. If you said everybody must be vaccinated, and if you're not vaccinated, you can't do X, Y, and Z, or you're not eligible for A, B, and C, there's a risk there of an age discrimination complaint, because the way in which the vaccine is being rolled out is dependent on age groups. So if you have a particular ruling of that sort, there's a clear risk of an indirect discrimination claim. People in the lower age brackets won't be able to comply with it, or less able to comply with it. And then you're into the tricky world of objective justification of a potentially discriminatory requirement. So it's not straightforward. And I think the thing that's emerging from this is be wary of blanket rules about vaccination and what people can and can't do. Where you do think there's a requirement, it's likely to be for a relatively small group of staff doing a particular job in light of other requirements, for example, those of a third-party company or of a different country. And there it starts to be more obvious that you can justify the approach you're taking. It's important, of course, to bear in mind also disability discrimination, because there are some conditions which, if people have them, it's suggested they shouldn't have the vaccine. Those conditions are likely to be serious enough to amount to a disability. So clearly the protection of the disability discrimination legislation comes in. And similarly with pregnancy and maternity, pregnant women are advised not to have the vaccine. So again, you can see how you've got to be quite careful about how you frame this. And if you are going to have a policy or a set of requirements, that you've made sure that you've built in appropriate exceptions and exemptions in order to avoid that discrimination risk. The other thing that's worth just mentioning, because it's intriguing and I think probably going to be tested at some point, is the question of religion and belief. Now, in some aspects, it's more obvious than others. So there may be people who, for religious belief reasons, don't wish to be vaccinated, including if the vaccines were to be derived from certain animal products, for example. But I don't think it'll be long before someone runs an argument that a belief, the sort of anti-vaccine movement belief, is one that's protected by the religion and belief legislation. And it'll be interesting to see. People have their own views as to whether or not that will fall into the definition. Broadly speaking, it would have to be genuinely held, cogent, serious, and worthy of respect in a democratic society. At the moment, my reading of it is that the case law is unlikely to hold that to be a belief that's protected, but I think we'll have to wait and see. I think it's important to be aware of the possibility that it would be, though on balance, I would say not. And then the last thing, just to cover off quickly on that, is the question of human rights. Of course, there's the Article 8 right to the right for private and family life not to be interfered with by a workplace requirement. I think it's going to depend on the circumstances, but clearly there are exceptions to that right, to that Article 8 right, which include measures that are necessary for public safety or the rights and freedoms and indeed health of other people. Final point, very quickly, data protection. Obviously, bear in mind that things like vaccination records are health records, so they are part of the special category of data, and you need to treat it accordingly where you're processing and controlling that particular sort of data.
Thanks, Matthew. Breaking for Q&A now. We've got 5 good questions on chat, and I'll just say in parentheses that Matthew and Deborah have offered to stay on after the 3 p.m. finish. So if you have questions, please do hang on there. This is a nice and nuanced one from Sarah. Is making sure that people remain connected, those informal moments and opportunities for collaboration that happen when you're together in an office, is that a legitimate reason to ask employees to return, provided, of course, the office is COVID secure?
So you mean as part of the social, to maintain the culture and the engagement? Is that what you're saying? Sorry, Richard.
Yeah, is that legitimate? Is that reason enough to ask employers to return? That there's opportunities when you're in the office for collaboration that don't happen online, and the culture.
I wouldn't say that on its own would be enough, because that's obviously that's where you do. That's part of the creativeness, isn't it? And you meet people and you talk and you chat and then you get something. And I think there are ways you could perhaps get around that, and maybe you have your hybrid working, so you have days when you work from home and then you have team days. That's what some organizations are doing. So they're actually having days when everyone is in, and that's when you get your interaction and you bounce ideas off each other, and then the rest of the time you're at work. But I think that solely is a reason to expect people to come back, when if you can do your job effectively at home, so that's the test from working from home, then I think that would be not enough on its own to get people back to work.
My take on it is encourage but not require, I would say, and it's going to be a moving picture. So that sort of suggestion is great. I mean, obviously, people get a lot out of seeing their colleagues, and as things improve, and as we move back, presumably to a tier system, and the vaccination program is more and more effective, then I think you can go from encouragement towards requirement, bearing in mind what I said about needing to take into account individuals' personal circumstances.
Okay. And what happens if you've done everything to make the workplace COVID secure, staff members refuse to come back to work because their work-life balance has been so much better and they don't want to return to commuting again? Can the employer enforce that after a period of time, as their place of work is the office address rather than home?
Well, then you'd be in the situation of, do they want to make a formal flexible working request? And then, of course, if that's the case, the employer has very valid reasons, 8 reasons for saying no. So it doesn't work with, the combination of the other colleagues. It doesn't work because of client demand. But if they've been doing it long term, then it's going to be harder to say this hasn't worked because they may have been doing it for months already. But I think the 2 issues there. If the workplace is safe enough for them to come back, then the issue for them not wanting to come back isn't the security of the workplace, it's if they prefer working from home. And you could say, for an organisational reason, permanent working from home full time isn't something you can accommodate. Then that's going to be very tricky for employers, and I think that's going to be an issue in the months ahead as well. Because how can you say it's not working when it's already worked for the past 9 months, when they may have been working from home all the time already?
I agree with that. I think it's going to be very difficult for employers to insist in a number of cases that someone must come back to the office 5 days a week, assuming that they're full time. But I think it would also be quite difficult for an employee whose job was originally office based to say, I want to work from home all the time. I think probably where we're going to end up is a mixture, a much broader scope, a much broader blend of working partly at home and partly back in the office.
Okay. If a clinically extremely vulnerable employee refuses a vaccine when they're now on full pay at home shielding, but not actually working from home, could we potentially revert them to sick leave or unpaid leave?
So that's an interesting question. I'm going to be really naughty and say it depends. And the reason I say that is because I think it's going to depend partly on the reason why they aren't being vaccinated. Because if it's, for example, that they're clinically extremely vulnerable and therefore have a condition which means that the medical advice is they shouldn't be vaccinated, you've got to be very careful that the treatment you afford them isn't then unfavourable treatment because of something arising in consequence of a disability. So just to follow that through, they've got a disability. As a result of that, they're not going to be vaccinated. Say, right, we're going to change the working arrangements in some way so you're not being paid as much, or you're in some way disadvantaged. You're going to crystallise a disability discrimination claim there. So I think it's really important to know why they don't want to be vaccinated. After that, then the question is, could they return to work with other mitigating measures in place? If they're clinically extremely vulnerable, I suspect that would be tricky, but those are the sorts of things that you would need to start exploring before you did anything that the employee might take as being disadvantageous to them.
Okay, thanks both. We have 5 minutes left, so I'm going to park the 2 remaining questions. Apologies, Kevin and Helen. You're first in the queue if we get to Q&A, or if you're able to stay on, you'd be very welcome. And then, sorry, over to you again, Deborah and Matthew, because I know you wanted to look at looking ahead to this year.
Yes. So these are the sorts of issues that we're just going to look ahead quickly for 2021. And the first one is post-Brexit. So the trade agreement was signed on the 30th of December. And I did have a look at it briefly for the relevant part. And if you were interested in where you would find all the information about workers' rights, it's part 2, Title 11, Chapter 6. And Chapter 6 refers to labour and social levels of protection. And under that agreement, there is no obligation for alignment. So that's the first key point. But labour and social levels of protection should not be weakened or reduced in a manner affecting trade or investment. So basically, they have to be maintained to the level that was in place at the end of the transition period. So we have already had a business review announced of post-Brexit workers' rights. And I was just talking to Richard before we started to say that this has already changed. So as of today, the Business Secretary has now confirmed that this review isn't happening after all. There was a bit of a kerfuffle last week. You probably heard about it. It was the review of the 48-hour time limit, working time directed rest breaks. Should holiday pay include overtime? So all of that review, which caused a lot of surprise that it was announced so quickly after the trade agreement, as of last night, has been pulled altogether. So we don't have any post-Brexit review of workers' rights at the moment. Irrespective of the agreement, you do need to remember about the Withdrawal Act, because retained EU law, which includes ECJ judgments, they are binding if they were before the end of the transition period, so anything up to the 31st of December, they can be overruled by the Supreme Court and Court of Appeal. And post-Brexit case law, we won't be bound by it. But still, our courts can choose to have regard to it if they think it's relevant to the case that's being heard before them at that time. Matthew.
Thank you. Just quickly on tribunal developments. So, as I suggested, the tribunals are doing their best under very challenging circumstances. Their CVP, cloud video platform, is working well for remote hearings, and generally that's okay, but the admin is definitely behind. There's a big increase in cases as well. I think that's a reflection of the job market. I think people are more likely to bring tribunal claims where they can't readily find work, and you can see on the side there's a 13% increase. Heard anecdotally today that the tribunal service is receiving 1,000 new claims a day. So you can imagine what that's doing to the ACAS Early Conciliation Service and the tribunals, and it's why you can't, I'm afraid, be sure that you won't get a tribunal claim just because the time limit has appeared to have passed without hearing from the tribunal. As Deborah mentioned, we're anticipating a spike in claims in relation to health and safety concerns and a spike in claims in relation to whistleblowing. And it's for those reasons that those sort of cases need particular care when you're dealing with issues within the workplace that might have the legs to go on to a tribunal claim. It's important also to say that if you're preparing tribunal cases, please make sure you're up to date with the guidance from the employment tribunals. There's presidential guidance from September last year, which sets out things like how to test that technology is working, how to make sure that your bundles of documents are properly indexed and linked so that it's easier to follow, and give guidance about the circumstances in which, for example, actually you do need an in-person hearing, for example, because someone has a disability. But we're looking at cases now being listed for an in-person hearing at the beginning of 2022. So clearly that's not great because of the fact that witnesses forget what happened and the whole thing becomes a bit stale. So the message is bear with the tribunals, they're doing their best, and be on your guard for the whistleblowing and health and safety cases in particular.
And on the whistleblowing point, Public Concern at Work, so now known as Protect, published an interesting report. They've saying they've been inundated with COVID-19 related calls, most about furlough fraud and some about public safety, health and safety issues such as lack of PPE. And obviously the point about whistleblowing is that it's again an automatic unfair dismissal, no qualifying period needed and no cap on compensation. Furlough fraud is the fastest emerging issue it has dealt with in its history. So there's some of the issues, and hopefully a lot of those will be rectified with the publication of the employer claim information that I mentioned at the start of the furlough section. Increase in statutory rates, so those are all self-explanatory, but just note, maybe not had as much publicity as you'd expect, the national living wage scope has been extended. So you only need to be a worker age 23 and over now and not over 25 from the 1st of April. We've got some increases in statutory rates for family-friendly payments and SSP. Long COVID, I think this would be an issue for 2021 and beyond, because it's possible that it could be a disability within the meaning of the Equality Act. But obviously at this stage, we don't have enough medical information or scientific information. But that's the definition of disability under the Equality Act. Physical, mental impairment, substantial long-term adverse effect. So the issue with COVID is whether the consequences are that people develop long COVID And the evidence so far is that tends to affect mostly people of working age, interestingly, so people over the age of 45, and slightly more women than men. And those symptoms, all of which can have an impact on your mental health, and if you suffer from it for many months, it could well meet that definition of disability under the Act. But ultimately, it'll be for the tribunal to decide. So I think that's going to be something we'll see in the months to come, more and more people suffering from long COVID, and then to what extent does it or does it not meet the definition of disability. New ways of working, we've all mentioned already the hybrid approach, part remote working, part at the workplace. And I think in the early days of the March lockdown, the very first one, it was just the practicalities. People needed to work from home. Is the IT sorted? Do they have equipment? And nothing else was really thought about. Working, and longer term, then what will it be? Will it be on a team basis, or will it depend on the business need? Will you be flexible? How do you meet the business needs with individuals? So we did a webinar back in December, and we did a poll, and it was interesting because we asked from an individual's perspective, what's your preferred working pattern? And only 8% wanted to go back to the office full time. The majority of people wanted to work 3 or 4 days at home. And then we asked the same question from the employer's perspective, and it was a complete mismatch. Most employers wanted more people back in the office for longer. So somewhere down the line, there'll be some interesting conversations you need to have with your staff. So as we've said, probably an increase in flexible working requests, where there are going to be permanent changes. You need to vary contracts of employment, and rewards and benefits. We've already touched on that with the London waiting. If you're providing a company car for somebody and they're doing most of their work from home, but they're not making the same business visits, do they need the car? If most people are working from home, will you carry on with your staff canteen? Will you provide the workplace crash? So all those sorts of things you need to think about if there's a longer term change to the way of working in your particular organisation.
Deborah, sorry, I'm just going to come in there because it's 3 o'clock. So if people need to leave, no problem at all. We quite understand. Should we? Have you just got a little bit more information you'd like to share? Am I right in saying that?
Yeah, I've got 5 minutes on just 4 cases. If people want to stay and listen to that, or we could go to the questions. Whatever you prefer, Richard.
Okay, we'll formally close it now.
Okay.
So that if people want to stay on, please feel free. Sorry, slightly overrun, but there's a lot you've got through really well there, I must say. So, so Deborah, back to you. We'll keep recording, and people can catch up if they wish. And thank you all for coming so far.
Just 4 cases to finish off, one of which you will definitely have heard of, and the other 3 you probably haven't, but that's why we've mentioned them. So this one is the first case relating to interim relief, which is a very specific remedy, and it could become increasingly important in the months ahead now that we know all about the long delays at the Employment Tribunal. And the reason it's important is because you must make your application if you're the employee within 7 days. So they are dealt with very quickly. And this related to a grievance back in July 2020, and you can see it's already been dealt with, done and dusted by the tribunal in a matter of months. You can only make a claim for interim relief in very specific circumstances, and where you say that your dismissal is connected to trade union activities or health and safety. In this case, the individual said that his subsequent dismissal was because the company were very hostile to trade unions. So he was dismissed when he got the help of a trade union member in July. He didn't agree to a reduction in wages, and this was the specific legislation that he relied on. And interim relief, which is an application to be reinstated pending the full hearing. So a very, very important remedy for an individual where it's available. And they said, on balance, we think you'll be able to show that your dismissal was connected to making use of the trade union rep. And on that basis, we will order reinstatement. So very, very important remedy. And as I say, we think they're going to be used increasingly in the months ahead. This is very important as well. Very important case about the extension of the scope of gender reassignment, protected characteristics. This was Ms. Taylor, who presented as male for many years at work and then started to present as female and became gender fluid non-binary. Suffered terrible abusive jokes, humiliation, harassment, horrible insults, and she eventually resigned and brought claims of harassment, discrimination. And she was successful, but before the remedies hearing, they actually agreed a settlement of 180,000. So what was important about this case was gender reassignment, in the meaning of the Equality Act, involves a process, and gender fluid non-binary doesn't have that process as such, but the tribunal judge came to the conclusion that gender was a spectrum, and it was beyond any doubt that that spectrum did come within that definition of gender reassignment. Now, what was also important about this case is that the judgment was very, very, very critical of the employer, so much so to the extent that they said, as part of our order, we require this judgment to be read by the board at the next board meeting, and we want a minute sent to the claimant that that had been done, because they wanted the company to take on board all the criticisms that the tribunal had about the lack of support available to Ms. Taylor. Last but one case, Vento ban, so that's awards for injury to feelings. And this is just to illustrate, and you'll see this is a tribunal case as well, so it may have passed you by because it wasn't at the EAT or Court of Appeal. This lady was on a training course, she was in her induction, and within the induction, so within a matter of weeks, horrible incidents of racist discrimination, harassment, and eventually she was signed off with work-related stress. So she started, I think, in February and didn't come back to work at all, so was dismissed in the October. So she was only in work for a matter of months. She had various claims of harassment, discrimination, and victimization, and it was found that they had created a hostile environment for her. And out of that award, £42,000 was for injury to feelings, and that's the very highest band, plus aggravated damages in addition to the injury to feelings. The Vento band for injury to feelings was in the highest band because what they identified was that this harassment, treatment, bullying, victimization was not done by one individual, but by a group of people, and that exacerbated the harm and the insult that she felt. And that's why the highest award was justified. So very important to bear that in mind, where you've got a group of people making somebody else feel very isolated from the rest of that team. And then the last case, very, very high profile, this one, so I don't need to spend much time on this. This is the Morrison's case and the data breach by the disgruntled employee who actually went to prison for 8 years for his data protection breaches. And they lost all the way along up until the Court of Appeal, even though they had some sympathy for Morrison's. The lower court said actually they were vicariously liable for Mr. Skelton's act for disclosing all these data breaches. But the Supreme Court held that you can be vicariously liable as an employer if there's a connection between the employment and the wrongdoing of the employee. But this individual had a personal grudge, he had malicious intent, and his acts, i.e. disclosing all that data, were not part of his employment, and there was no connection to that, and so Morrison's should not be held liable. So as I say, that one got a lot of publicity, and you probably would have read about that at the time. So that's the end of our session. I think we've got time for questions, and those are the contact details if there's anything else you'd like to ask. So thank you very much, and apologies that we ran over, but we've obviously had lots of good questions to answer, and I think if we want to stay on the line, we can do some more. All right.